Today our topic is about application for rejection of plaint. Firstly, let us know what is plaint. A plaint is also known as pleading and is a document of law containing the plaintiff's written statement mentioning in his claims. So, when we given the complaint to any of court like civil or commercial court, so it is adjudicating the civil cases which will be adjusted according to the provisions of civil court. So, Order 7 of Civil Procedure Code, which is dealt with plaint. Order 7 is constituted with 18 rules. I would like to add my article to discuss in terms grounds for dismissal, post-dismissal, statute of limitations within which the claims which have to be relieved or which have to be informed in other informational materials. So we already overthrew with the plaint or what is meant by plaint. Now let us know that the main objective of plaint. A plaint is to demonstrate the wants of the plaintiff. Like which we already seen that a plaintiff who prescribed to the damages. So the damages have to be clear by initiating with a suit to recovery of the damages. Like that, this rule is merely a professional or procedural rule ensuring nothing which is more than the correct application which is mentioned under the Court Fees Act 1870. Now, let us go through with what is Order 7 Rule 11. This the Code of Civil Procedure 1908 which contains provisions relating to all types of disputes which are in civil nature. So that when we are going to file a civil suit, according to the provisions, the court is obligation to determine the case which is the civil suit or whether the court is described or prescribed under the civil suit, so that the lawsuit is accepted or not. Coming to next part, the rejection of plaint, which is dealt by the Rule 11 to 13 of Order 7. So, here the court may do one of three things. So as we all know that court must have to follow the rules and regulations. As we all know that there are many substantial issues raised by the parties. Here the three things which could be accepted by the court is, first one is acceptance complaints. Second one is denial of complaint. Third one is transfer the complaint to the plaintiff or litigating party. So, with the problem or issue raised by the plaint, here the complaint which we have to be taken is the valid points are considered to be taken, or the complaint should be acceptance way. Or second one is denial of complaint. Here one is acceptance and alternate one, another one is denial. So denial of complaint is also very important. And coming to third one, which is most precious and important to this, transfer of the complaint to the plaintiff or litigating party. Where the plaint which have to be mentioned under the Order 7 Rule 11 have to cross check all the points which have mentioned in the complaint, so that the court to carry its duty have to be in easy way. So we have to check the grounds for dismissing a claim when the dismissal of the complaint have to be occurs. Before dealing all these basic rules, we have to note that filing of a complaint to initiate a lawsuit is mandatory in all cases. Where the complainant filed a complaint in a court or in that particular territorial area, so that each court is obliged to verify the complaint and determine its admissibility for the purpose of order. So, the court has responsibility to verify all the complaints and determine that it should be in admissibility or not, or it should be in the admissibility purpose of Order 7 Rule 11, and we have to cross check all the details which should be mentioned under the court prescription. What is plaint and the main objective of the plaint? Now let us see some more objectives and scope of rejection of plaint. The primary objective of Order 7 Rule 11, which have to dismiss complaints that are frivolous, vexatious and improper in nature. So, we know that the complaint should be in an acceptancy way, which are not in acceptance, which may lead to dismissal of the complaint. So, here dismissal of complaints which are in improper way or very illusory manner or frivolous, so that the outset date by saving the time and judicial resources. So, the inadmissibility of the court which leads to damages occurs through the court like timing, wastage of time and judicial resources. So, such remedies are necessary to end wrongful resources and save more legal time. So, firstly, we all see that in case of Dahiben versus Arvind Bhai Kalyani Bhanswali in the year 2020. So, we all go through with the case and let us know some more information through that case law. Now, going to rejection of complaint or plaint. Order 7 Rule 11 of the Civil Procedure Code specifically provides dismissal of complaints in certain cases. So, certain cases which describes dismissal of provisions of court through the complaint. When the dismissal occurs of the complaint should be in improper way, frivolous, vexatious or terminated to be in automatically dismissal of the complaint. So, let us know according to that provisions through cause of action or issues in controversy. So, certain cases which describes dismissal of provisions of court through the complaint. When the dismissal occurs of the complaint should be in improper way, frivolous, vexatious or terminated to be in automatically dismissal of the complaint. So, let us know according to that provisions through cause of action or issues in controversy. So, particularly the plaint mentioned a number of grounds on which the complaint would be dismissed by the court. There is no need to mention the cause of action which was pursued by the plaintiff against defendant. So, it states that plaint shall be rejected if any grounds specified in the clause A, clause E are made out. So, Order 7 Rule 11 clause A to E which are made out through the plaint should be rejected, which are not in specified grounds in manner. If the court finds that plaint does not disclose a cause of action or the suit is barred by any law. So, if court finds that the plaint do not mention the cause of action, in case that the court has no option but so the rejection of plaint have to be occurs. Here, some of the times cause of action must to be in a sufficient cause or cause of action must to be mentioned which is barred by the law. Let us know what is meant by cause of action. Cause of action nothing but it divides into two subdivisionals. One is legal theory and one is legal remedy. Legal theory is nothing but a factual situation where the claims of plaintiff occurs. Next, what is legal remedy? Legal remedy comes that where the plaintiff gets relief from the damages which have to be occur in the specified complaint. So, if the amount of compensation which to be demanded by the plaintiff which is lesser than the requisite, so the plaint can be rejected automatically. The claim needs to be corrected within the time which is prescribed by the court. So, where the plaintiff occurs or pleadings or the plaint have to be requested to recovery of the damages, the claim needs to be corrected in the prescribed court in prescribed time. So, that particular rejection amounts to dismissal of the suits. So, within time or within the court prescription, the plaint have to be compensate the amount. Otherwise, the court will be automatically dismissal of the suits have to be occur. Plaint is rejected if it is vexatious, illusory, cause of action and barred by limitation. When plaint is rejected through cause of action, where it would be in insufficient cause throughout the barred by the limitation. So, the dismissal of the complaint under Order 7 must be decided. So, defendant, where the defendant cannot be required to submit a written statement without ruling the request. So, where the dismissal of plaint occurs, defendant do not need any written submissions to be submitted. So, if any, otherwise the defendant need not be required to submit any written documents without stating the court prescription. Court main duty is to carefully consider the complaint. Here, when the plaint given the complaint under the court, it should be accepted or postponed for resolution, which is decided by the particular court. However, complaint will certainly be rejected by the court when the cause of action is not mentioned improperly, or when the cause of action is going to be in lying way and it is not in proper jurisdiction and limitation. So, as part of that cause of action can be considered the entitled of a person to be in a legal action against the wrongdoer. So, we all know that what is meant by plaint and the objectives of the plaint. Now, let us know the cause of action of the plaint. Cause of action is very important in this Code of Civil Procedure 1908, which rights and responsibilities entitled by the legal rights according to relevant regulations. And when if violated by another individual of one individual, it will be handled according to law for that particular matters. Under 7 Rule 11, additionally, the court will dismiss a complaint if it is made on paper that has not been properly stamped and authorized. So, the plaint must secure all the properties or all the details mentioned under the complaint is mandatory to check all the stamped and authorized signatures must be in proper way, and the paper has not been valid or paper has been not taken into consideration while the stamped and authorized was not in proper way. So, automatically the dismiss of complaint has to be raised. If the person cannot cover the defect, he or she can claim as indigent to continue the proceedings. So, the person who are not covering the deficit, so he can claim as indigent to continue the proceedings. Where the person are unable to pay certain things or certain factual proceedings, so she or he automatically continue with the indigent terms to the proceedings. The defendant had a chance to file a request to dismiss the lawsuit on the grounds that the lawsuit is carefully buried. So, it is a chance to the defendant to file a request to dismiss the lawsuit against us or against the plaint. And the lawsuit is clearly buried by the law. We learned that what is plaint, what is main objectives of the plaint, and what is cause of action required for the application of rejection of plaint. So here, I would like to conclude my topic. The Civil Procedure Code is a comprehensive law that covers entire procedure to be followed by all civil suits in India. So, filing a complaint is the first step in taking legal action. And second thing is drafting with diligence. The filing of complaint, which is important in first process, and second process is must and should be in drafting process, and which is important in legal framework. So, it must include all information mentioned in Order 7 of the Code, where the plaint have to be mentioned the damages occurs or damages raised. So, the plaint must include all the matter with pin to pin in the information must be needed according to the relevant regulations. So, other than it is violated by another individual which handled according to the law. So, the statutes of presumptive decree, the law's clear statement that if there is no bar to filing a fresh complaint on the basis that the previous complaint has been dismissed and ensure adequate mitigation. So, where we are going to fail to submit the documents when we given the complaint, and it is automatically dismissal of the complaint. When dismissal of the complaint rise in, it goes to previous complaint and has been dismissed, and there is no bar to file a fresh complaint again. So, here we have to know all the process and applications according to the material fact, the description of plaintiff which is mandatory to require in Order 7 to the fundamental rules and regulations according to the court of law prescribed by the Barrett. Thank you, friends.